Good morning. Nobody is here. But it looks like we're going to have a hearing this morning. We're probably not going to get opening statements until later today. How come? Why is it doing that? Well, let me share my screen. Oh, there we go. Any day now. I don't know why my computer's being slow this morning. Come on. You can do it. I'm hardwired in too. What is the problem? There we go. Good morning, James. Oh, I don't know when this hearing's going to start. It's probably going to do the same thing it did yesterday. Well, darn it. Well, dang it. I don't know how to do it. Oh, well. Anyway, you know those pictures you see of dogs holding signs? Not holding signs, but they have signs in front of them. I made a picture like that with Spike because I accused him of pooping in the house yesterday on the live stream. And it wasn't him, it was Belle. So I made a little sign and I put it in front of Spike and I took a picture because he needs a lawyer now because he's suing me for slander. Because the whole internet heard yesterday that he pooped in the house and it wasn't him, it was the other dog. So. But I don't know how to share the picture. And I think this might be another, I'm going to take care of other business first day because I don't see any activity in the court. But there were other documents. And it's Owens just keeps amending his documents. It's like he goes to court with a document to suppress whatever. And then he gets up in front of the judge and he says, his argument. And then the judge asks him questions. And then he says, I'm not ready to address that right now, judge. And then he goes back and then he writes an amended motion. And then it seems like they go to the hearing and then the judge asks him questions and then he says, I'm not ready to address that right now, judge. And then he goes back to his office and he writes another amended motion. And then it's amended motion. I hope that he's ready to address that when the trial starts cuz he's done that more than once now. Like he did it yesterday. Like the trial is underway now. This is not the time to say I'm not ready to address that. This is the time to address that. You this is you don't get do-overs now. This is well, in my defense, Spike does not like to go outside to poop. And I don't I don't know what scared him, but apparently at some point something outside scared him. And of course, when they are pooping, they're at their most vulnerable, and so I get it. And so it's usually him. But we can tell the difference. And he does his business all in one spot. Belle leaves a trail that I didn't see yesterday, but my husband found more. So then we were like, oh, I accused the wrong dog. And I did it on a live stream. It was like, uh-oh, he needs a lawyer now. So who should represent Spike? Rob, Emily, Alita, Mike. We should get Mike. Yeah. Should get a hold of Mike Gravlin. My dog needs an attorney. I mean, wasn't Emily Rob's dog's lawyer when he chewed through some cable or something? Come on, people. Why is he doing other business on a trial day? That's the thing I don't understand. I'm not awake yet. In case you can't tell, I'm not awake yet. I had Alexa set an alarm for 7:30 and 8. And yesterday morning when it went off at 7:30, I said, "Alexa, stop," in my sleep. Didn't miss a beat. Alexa, stop, and rolled over and went right back to sleep. Hey, Flash. I think this is just a hearing, another hearing, because there was more documents. Although they were just amended You know how Owens does amended, amended, amended. I have never in my life, though, seen so many attorneys get up to argue and not be ready to argue. I mean, even Henderson. Yesterday, he was like, he gets up there and he starts an argument, and then he's like, "Oh, just a minute, judge," and he goes back to talk to co-counsel. Dude, have your argument ready before you go to the podium. That's just insane. I'm proud of you, Flash fan. Oh, now we have a clock. Yes. Come on, computer. Yes, please don't forget to like and welcome replay crew. That one was from yesterday. I thought I saw a new one. Maybe I didn't. Oh, wait. What is this one? Oh, that's just an evidence control sheet. Okay, so there's not any new ones. So what are we having a hearing on then? States response, defendant's fifth amended reciprocal discovery exhibit list. That's 10 pages long. Did we read this one? I don't know if we read this one. I don't remember reading a state's response that was 10 pages long. Yay! Freddie Mercury has entered the chat. You know, there is a Nintendo alarm clock now. And I am a Nintendo girl. Like, I have a PlayStation. I've never had an Xbox. I don't want an Xbox. I have no desire to have an Xbox. But I love my Nintendo. Like, I have PlayStation games that I have bought a second time for my Switch because I'd rather have them for Switch. So I see this Nintendo alarm clock and I'm thinking, oh, cool, I want one. And then I watch the video. And in the video, yeah, in the video, it's all adults. And they're like stretching and moving, and like you can hear the Mario coins when they move. Like they're getting coins for like every movement they make. And I'm like, why are adults doing this? This is stupid. Yeah, that is um Trial TV Live. And they are affiliating with Top Mark Media, which belongs to Recovery Addict. Um so it's going to be also streamed to Top Mark Media. But I don't know if we can watch it on there or not. But Recovery Addict is going to stream it on his channel with commentary. Um, but right now he's doing the Melody Ferris trial. But as soon as this one starts with like opening statements, he's going to switch back over and then he's going to play catch up with the Melody Ferris trial. And right now, um, no, I think they're just an independent creator. But Recovery Addict actually shipped some of his equipment down there because he's in North Carolina. So he shipped some of his equipment to whoever runs Trial TV Live, who's actually there, um, in order for like the sound, because Scott's a sound guy. Recovery Addict's a sound guy, and he actually went to college to learn how to use all the equipment that he uses. He's a hardware guy. Like he doesn't use software. He uses hardware to do everything, pretty much, and he ships stuff down there. Um, no, jury selection isn't over. So what's happening today is another hearing, and I don't know what. I don't know what happened yesterday after that hearing that prompted them to need another hearing, but I just woke up and saw, because I've been checking because I want to stay on top of this, and I saw all these different channels that are covering this are going live at 9. So I was like, okay, well, I better go live at 9. And a bunch of them said it was a hearing. So I'm like, okay, well, I don't know. I didn't hear anything about another hearing, but I'm not going to miss it. So here I am. And now it's 9:19, or for David that would be 8:19, and nothing's happening. So I don't know, but I'm here. Oh, we have movement. There she is. And then they're gonna, after this, I guess they're gonna finish jury selection, and hopefully opening statements will be this afternoon. I do too. The only thing is they have to be mindful of not showing the jury. And the problem with jury selection is that if they get into in-depth things with a juror, well, number one, people could recognize their voice and know who they are. Number two, they could get into like private type information. Like this is a DV case. So if someone gets into like, oh well, I'm a victim of DV and I don't impartial for this case, whatever. Um then I wouldn't want like my whole personal backstory why I can't be on a trial broadcast to all of the internet and all the world. You know what I mean? So I get it. I get why they don't. I almost watched it. Sarah, you screwed up your hair, girlfriend. Um, I almost watched it just to like get the see how it's done because I've never watched jury selection, but I was so the Melody Ferris, the woman that's on trial for killing her husband, her boyfriend was on the stand. Well, they're exes now, but the guy she was seeing while she was married to the man that she supposedly killed was on the stand. So I didn't watch the jury selection yesterday afternoon. And I'm missing his cross examination right now. So when this is over, when they go back to jury selection, I'm going to go back and watch her lover's cross examination because that's going to be spicy. Oh, really? So apparently, one juror tested positive for COVID. Another juror was sick, but tested negative. I think they're still on the jury. And then there was another one that just left. I guess he just decided he didn't want to be on the jury. So he just got up and left.
William J. for the state.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? Ms. Boone is seated at council's table wearing a dark gray suit and a
He
yellow
doesn't have a
blouse.
middle name.
She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay. Madam Clerk has advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can't hear you.
State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half.
Okay.
And then we've got laws and territorial.
Correct.
I believe we each have 10 strikes.
That's correct.
So that's going to take.
Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. We could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed.
Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay, all right.
What is happening?
Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay, all right, then we'll take a short recess. Just let us know when you're prepared to give us that ruling and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State, or Mr. Owens? How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion limine regarding anticipation of affirmative. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. Thank you.
What just happened? Every time the seasons change. Okay, well, not every time, because Florida doesn't have 4 season changes. They only have 2, spring and fall. My allergies act up, and my eyes are itching so bad right now. I sent you an invite, Draco and me. So I wish I could figure out how to show you guys that picture. Oh well. It's not a great picture anyway. It's just a picture of my Spike not looking at me, being mad at me. Because I accused him of pooping in the house and it wasn't him. He's my little buddy. He's wherever I am. Unless it's wherever his daddy is. Right now he's licking the rug under the table. Dude, why are you licking that rug? That's gross. I don't know why. I keep dropping frames. I don't know why. I'm hardwired in. Why? Why?
Helps if I unmute. Hello.
Hello. Yay.
Trial will start in
Yay.
2027. How you doing?
I
Can you
was
hear me?
trying to find. I have that Titanic clip. Yes, I can hear you.
Okay, cool.
don't know why my computer is so slow today.
It's so annoying when it does that.
There we go. No. I think it's StreamYard. Because I'll click on something and it won't go. And then I'll click on it again and it'll do what I wanted it to do and then undo it. Like,
Yeah, I'm sort of trying to figure it out too. Now, is it working? I sort of missed the beginning. Has anything much happened?
It's been 84 years.
Yeah, it really has. Oh boy. You're muted at the moment, just so you know.
I don't know why it keeps muting my mic. That's the second time it muted me for no reason.
Technology.
I don't have a lot of good clips for trials. I have clips for like my true crime videos. This one's one of my favorites though. If it'll play. Let's see if it'll play. That's from Supernatural.
Yeah, okay. Don't know that I've ever actually watched Supernatural. Heard about it.
Yeah, they're monster hunters and the fairies were bad fairies in that one. There's another part in that show I wanted to get the clip of, but I couldn't find it, where Dean's saying, "Is the crazy on me?" I feel like the crazy is on me because they, like, interviewed a woman that was talking about fairies,
Yep.
and she's very obviously, her elevator doesn't go all the way to the top. And he's like, "Is it
Fair
crazy on
enough.
me? I feel like it's on me," but I couldn't find the clip anywhere.
Yeah, fair enough.
I love that one but I have to go back through all my old videos because, uh, Criminal Minds, the little clips,
Yep.
the little clips that I use from Criminal Minds, I'm taking them off. I'm not, like, taking them out of the show. They are like, I'm not on CBS taking them off of CBS. I'm taking them off of YouTube where other people have uploaded them. But those videos aren't gonna be monetized whenever I am able to apply for monetization, so now I have to go through and cut out all those clips.
Yeah.
Yeah.
Copyright stuff is so confusing.
But there's some things that are it'll say copyright, but then when you click on the details, it'll say that it doesn't impact the video in any way. Like, I'm allowed to use it, and it doesn't say that it won't get monetized. It just it's like the person, whoever made it or whatever, it's like, "Oh, you can use it. I just want you to know that it belongs to me," you know? So,
Yeah. Yep.
I guess
Well,
I
with the
I
gameplay
don't have to
videos,
change those. Yeah.
because some of the
See, that's
gameplay
another
videos
thing I
they've got
wonder about.
they've got like copyright claims, but they're allowed to be used on YouTube, so it sort of works out. And I mean, I'm not monetized, so it's not a
Yeah,
huge thing anyway.
yeah. And the Criminal Minds clips, at first, it didn't s it said copyright, but that was it. Just like, you're allowed to use it. But then when Criminal Minds Evolution came out, because before it was off the air. When it came back on the air as just, a Paramount Plus show, like, so it's just a streaming show now, it's not on CBS anymore.
Yep.
That's when it started saying that it was blocked. This video is partially blocked in some countries.
Yeah.
That's
Okay.
when they started to say that it wouldn't get monetized. That's when the copyright became a problem after
Yeah.
the new show came back out. So, after they changed it to Criminal Minds Evolution. So now I have to go back through all my old videos and take all those clips out. But, I did the last video I did had 2 clips in it from BuzzFeed, and I just, I just knew they were gonna copyright claim, and I was so happy when they didn't. I was like, I went into Biggin's chat that evening, and I was like, "I'm in such a good mood, ask me why." So I was like, "Yay,
Fair enough.
they didn't copyright claim me." Well,
Okay, sorry, I'm just setting up the stream myself.
I know, but I know what fair use is, but it says it won't be monetized because it's blocked in some countries. So, and I'm only taking teeny tiny little clips. It's not like half the show or anything is in it. And what I don't understand is why still pictures aren't treated the same way as video. Like, I don't get it, because I've got still pictures from the shows in the video, and they don't say anything about that. I thought about leaving them in and then, like, putting a filter over top of them, but the ones that are just in there, see, why is it doing that? Did you guys just see that? Did that do that on your end?
Yeah, it's all shaking.
Where it was just, like, the buffer circle for a second? I'm hardwired in, I don't know why it's doing that. Yeah, CW used to have good shows, now they're Teen Wolf, wasn't that on the CW? They're talking about, well, they've been talking about it, a Supernatural reboot. That was my favorite show. Really? See, that's something else I need to do. I need to go through the list of words. I only know what other creators don't say. Why is it doing that? Stop.
I think it is a lot better now.
unalive,
Yeah.
an essay. But then a lot of and pew pew, like, and a lot of times though, I'll forget and say the regular word, and I don't know what to say, and
I think mostly it comes down to like hate words or very sexually explicit words. But I mean, as far as monetization goes, you've got monetization of your channel, and then each stream is different, and you can get reduced monetization or be demonetized for that stream depending on the content.
well, true crime channels are monetized, and there's all kinds of gruesome stuff in true crime channels.
Yeah.
So I don't see how using the words keep you from getting monetized. Because, I mean, yeah, they do use euphemisms a lot, but
I think
a
it's
lot
to
of
do with
times they don't, and they're
advertising
talking
too.
about very gruesome true crimes. And
See, it might be different having memberships and that sort of thing as against getting ad
oh
revenue.
yeah, because some advertisers won't advertise. Yeah, they won't advertise on certain channels that say certain things, I guess.
Yeah. So I think it's more along those lines.
How is saying first? How is saying that gonna get a channel struck?
Unless you're talking about the
Those
big
sound
M.
like interesting shows. Yeah, we don't have regular TV anymore. We just we just have streaming services. And
Does anybody
every
watch TV
football
anymore?
season every football season my husband and I go through this. Which streaming service has football games? Oh, CW app. Yeah, but I wonder, do I have to have um a television provider to see it? Because a lot of those apps, they're like, watch us on the free app, and then you download the app, and then they're like, oh, we need to know your TV provider. I don't have one, so then I can't use it. But okay, it's past 9:45. It's 9:49.
Fashionably late?
I was gonna say something. I forgot what I was talking about. I do that quite a bit, though. That's just
Yeah, that happens. I know YouTube did get very strict
the way
about
my
what you
brain
could
works.
actually say, but I think it's getting a bit easier now. It's not as bad.
Well, yeah, like the last video that I did, the devil made me do it murder. That one, like, I would fully understand if that one didn't get monetized. Because that one talks about demons and the devil and murder and
Yeah. And then, of course, there's a difference between a
although
copyright claim and then a copyright strike. The strike is the bad one, the
right,
claim is just whatever.
right, right. Oh, I'll have to look into that. Yeah, and when you've got a smart TV, they have all kinds of free streaming apps on there too. The only thing with that is, you're at the mercy of whatever they offer. You don't get to watch what you want to watch, but sometimes you can find some cool stuff on those channels too. I found something free the other day that I got all excited over. I can't remember what it was now.
Yeah, the other crazy thing with YouTube is they put ads on things
So
even though I don't
I'm
actually
like
get any money for it.
Yeah, I don't think I've ever seen any ads at all on mine. But with your gaming stuff, you're probably not gonna have any trouble. Oh, we have movement. Oh, wait a minute. That's not gonna work. Oh, there we go. Maybe. Are you gonna do something? Come on. Why isn't it doing it? Hang on. I'm gonna take you off stage for a minute. What is it doing?
Okay, is it working? I can try and get it if it needs it.
We're back on the record. Case number 2020 CF
Okay.
2603, State of Florida versus Sarah Boone. We get appearances for the state.
Man, I wish they'd put mics on
I
everybody.
don't know why you're putting. I can hear you.
Okay, Miss Boone will table wearing the same clothing from this morning. Miss Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Oh, that cures itself. Counselor? Record reflect that Mr. Beck has just entered the courtroom. All right. The court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday, and my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Yay!
Okay.
Oh, now I'm black. Oh, now
The
we're
court's
both black.
reviewed it. Are there any questions with regards to the
It's
court's
looking good from
rulings
my end.
on that motion?
Yes, Your Honor.
Yes, sir.
Court feed's a little bit choppy, but apart from that, it seems okay. It sounds good. Oh, now you're gone. Um. Let's see. What about
Okay. Are we good now?
We can get it working. Don't you love technology? No,
Yeah,
where's
I got
my
an
thing?
Ethernet cable, so I wouldn't do that anymore.
I can try sharing my screen if that helps.
No, I think we're good now.
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1,
Okay.
lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page. Florida 4th DCA 1971. Reed, REID versus State 213 Southern 3rd 1110 at page 1111. Florida 5th DCA 2017. Rudin versus State 182 Southern 3rd 724 at page 726. Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled B, battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for Dyer? Are we talking about opening statement?
War Dyer?
During the testimony of the trial.
That was my takeaway.
He's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 Southern 2nd, 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was or that the defendant was apprehensive of the victim at the time of the homicide, internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Even the closed captions can't hear him.
Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that I beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6th DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with or dire or
That is correct. And the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right. Thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that Fifth Amended Reciprocal Discovery Exhibit List filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right. Regarding item number 1 on the Fifth Amended Reciprocal Discovery Exhibit List from the defendant, I do not believe we have received those records.
Response from the defense.
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions or the objection is sustained. Moving to 3.
Paren short for parentheses?
Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not.
How are they still
based
going
on
through
what I
discovery at this
myself.
stage?
But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense.
Oh my God.
Which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Miss Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2,
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time. The 81 pages are not at issue. And what do the 119 pages evidence?
Their medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it would cooperate. Her testimony that she suffered an injury at the hands of George Torres.
There's a microphone right there in front of him.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
Where are you going, dude? The judge is talking to you.
Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
A Richardson hearing is a hearing to conduct an inquiry into the surrounding facts and circumstances of an alleged discovery violation. For example, a Richardson hearing might be requested because the opposing party attempts to call a witness not included on their witness list.
Yeah, so the issue is the defense
apparently,
has provided a
state-
whole bunch of photos that the state just does not have any record of. And the defense is trying to say, well, we only just got
Right.
them ourselves, but and now he's trying to say that they need to be matched up when she was injured in the records. It sounds like a delay tactic to me.
Yeah.
When did you receive them last week?
He doesn't even know.
He's never knows. He's never prepared.
Okay. I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what. Understood. All right. Well, I'll
Not
make a
quite
note
sure how to
to
turn
circle
myself
back to
down.
this issue.
I'll sit back a bit.
Moving
Does that
to
help?
number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the BAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Judge, we'll work on that.
Appreciate it.
I've got staff here in the
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5.
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to the various medical facilities asking for records. And we're just waiting on response.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. the state
But not relevant.
just having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 22320, several times a
So
week.
not an alcoholic?
The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
So I wonder if it's on the defense or the prosecution to have
the
relevance.
Addressed
podium.
yesterday. That's not germane to the issue.
As soon as I got to the records, I sent them. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing this exhibit. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper, if she has not reviewed these records yet? When do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post-evaluation, the last date that I believe she saw Ms. Boone was September 30th or October 1st.
Why is this happening now? The trial's already started.
So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's being relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will think about the deposition. So I'll wait. I will not ask her to review.
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence.
Police reports are hearsay. They're not admitted anyway.
Reports may be used to refresh the officer's memory if needed during the testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the document.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens?
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know we had some priors in Pennsylvania, Massachusetts. We're not referring to those. We're only referring to the one involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. If it's oral testimony, that may be a different critter once the overt act is established under Holland.
A different critter.
Judge, she's gonna testify to it, and then, it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is gonna cooperate with Sarah Boone's testimony about her injuries, photographs, officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. Disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Rennie will testify, I've seen Dr. Hunt will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. Her family can't help her, she has the state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases. So she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt that threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Warren says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in the court record indicating that the state attorney just.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your
So I
exhibit
think they're
list.
trying to get at the evidence of her being beaten,
Okay.
and
all right.
there
So
isn't
based
a
on
lot.
counsel's representation, draw the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19.
And they're trying to
Orange
say
County
that she had
Sheriff's
nowhere
Office
to turn to.
investigative workup report
But again, it's all her testimony.
response.
Used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I
Aw.
believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one.
Aw, kitty, so
Then,
pretty.
based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, the anticipated, is going to testify for the state, and testify for the defense, and he may be considered an adverse witness or a hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that force of their.
What does
Based on what he says,
what does the non-payment of alimony have to do with what's happening in a family case?
well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony for, he's supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Who's biased?
Ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress.
What does that have to do with the
It sounds
case?
like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because that's not my case and I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know.
He did
Can you all
relocate.
approach this for a moment?
He lives in Gainesville now.
Also, what does this have to do with the current case? Are they trying to get at the battered spouse thing still, or are they undermining him as a witness?
I have no idea. It's not relevant to this case. Not at all. Seriously, how are you going to pay alimony to a woman that's in jail? I mean, I guess technically he could still pay it and it be put aside somehow for her in case she's found innocent and gets out. But why bring it up during her trial? It has nothing to do with the trial. There's a whole different judge that's handling that mess.
Problem is, the lawyers don't even seem to know what they're doing.
Her lawyers have not been 100% prepared about anything.
So
Oh,
if
she wants
Brian is
funds
biased
now
against.
so she can buy stuff at the commissary. Hey, Nancy, you haven't really missed much. It's just Owens being stupid, wanting to admit stuff into trial that's not relevant.
So are they trying to get to her character referencing or undermining him as a witness?
I don't know. I don't know what side he's testifying for either. That would make more sense if I knew if he's testifying for her or against her. But if he's going to ask, have you been paying your alimony? I would think he's going to testify for the prosecution because that's not going to look good for him. He's testifying for both? The Three Stooges. Yeah, that's what we're going to start calling her lawyers. The Three Stooges.
But I mean, we're this far in and they're go through discovery and figure out what's going on, and it's such a mess.
And it was supposed to start on the 7th. But an act of God gave Owens his continuance. He got a whole extra week. He has sole custody of his son, and he's moved away. I was going to say, if she does win, I wonder if she'll move up here to be close to Lucas, but I don't think she's going to win. Not after the jury sees that video.
Yeah. Nancy, hello. Well, at least these ones are all having a good time.
I'm getting so tired of text messages asking me who I'm going to vote for. None of your business.
Yeah, politics,
I
eh?
haven't even got my ballot yet. Yeah. I'm supposed to get my mail-in ballot, and I haven't got it yet. Because I don't go out in public unless I have to.
Same. Thanks, David. Hello.
All right, thank you all both for your arguments and clarifications. Based on, court's going to overrule the objection at this time for the reasons discussed at sidebar.
I
Moving
don't even
now to
remember what the
23,
objection
the
was now.
policies and procedures of the Orange County Sheriff's Office regarding Miranda.
I don't either.
Have those been received by
This
you?
hearing's a mess. I was
Mr.
following
Owens?
along yesterday
Yes, sir.
good, but
Okay.
I'm no longer seeking to introduce those.
Okay, all right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay, all right, thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No. Not that I know of.
Right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay. And the court takes no action based on counsel's representation. Moving to 32, iPhone photo.
So are
Yeah,
they
I'm
still
sorry, sir.
going through the evidence? Have we even got to the Richards hearing
There is
yet?
none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objections. State, any response?
Any and all exhibits previously listed by the state.
I think this is the Richardson hearing.
Well, they seem to still be going through the evidence of what they're
Yes, sir.
admitting and what they're not. I'm confused.
I am too. This is a mess compared to the one yesterday.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified.
He's at the podium and we still can't hear him.
This motion in limiting to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to
constitute.
clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word
Well-
overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something
Would you
that
prefer if it
happens
was
every day,
first degree murder?
and that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents
No,
specifically
second
are y'all
degree.
going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together.
I'll be
within
right back. Give me a
5
second.
feet of Sarah Boone, first week of October, and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is. Then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter.
Oh,
That's on
kitty.
you. Sarah, I can't breathe.
Oh, she's
Laughter.
nicer than my
That's on
kitty.
you.
My kitty's
Sarah.
mean.
Unintelligible, drunken, slurred words. Laughter. Sarah. Sarah. Sarah, I can't breathe, baby. That's what I feel like when you cheat on me. Sarah. F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. That is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down.
So basically,
Mitch,
I think the
independent
defense is
sources
saying
tell
that the prosecution hasn't explained
by the
what they're
medical
actually
examiner,
charging her with, so
all
how
but
can
one
we
more
defend
trauma
against it?
to both sides
And
of
now
the
the
space
state is
and
saying,
mouth.
well, this is what we're
That
doing.
is a second-degree murder case. That is what we're going to be presenting.
Is it too
This is a
loud? I don't know
portion
how
of
to
what I will be
turn
telling
me
the jury this
down.
afternoon.
I don't think turning that
Any
turns it
rebuttal?
down, does it?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization
Is that better?
that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment.
Okay, I've moved it away. Is that better?
Because
Not
I
as
can't
loud?
testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. It's
That's
just going to have to be testified to by Sarah Boone and then Dr. Werner.
that's what she said. They're not characterizing it.
While we're here, they are going to have to decide who to believe.
The jury decides.
But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office.
Why are we still taking depositions?
Okay, is that accurate, Mr. Owens? That
I have no
October
idea.
3 states list?
Sounds like he's trying to take
I don't
depositions
know.
of his own witnesses.
They've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining. In no case,
Yes, you are.
days, as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the 3 fundamentals. But the defense lawyer makes the decision about which witnesses to call.
He's not going to get a
Although
continuance.
She may want some witnesses. She's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank
She's
you.
not happy.
So, what I think just happened with that last part, the list that they were going over what they wanted to include or not include or whatever, that thoroughly confused me. I was following along fine yesterday, but that list of stuff, I don't know. But what he said, and the judge told him he was wrong, but Owens gets up there and he's like, yesterday I was forced to tell what the overt act was. That wasn't an overt act. He stuck his fingers out of the suitcase. That was not an instance that he could stick his fingers out of the suitcase. That was a space that she left for him to unzip himself. Him sticking his fingers out was not an overt act of violence.
No.
But he said they felt forced to present what they said the overt act of violence was. So he wanted the state to state what their case was. So that's why he was going through all that about the video. And that is their case. And then he gets up there and says, I don't like the characterization. That's not a characterization. That's word for word what happened. It's on the video. So that's their case. That can't get thrown out. That's their case.
And he seems to be very much, well,
She
the
did what
state
she
did
did and
this,
she
so why
recorded it.
can't we do it?
So
Yeah.
yeah. Yeah, David. That would make you kind of special if you're deathly afraid of fingers. Well, if you're afraid of fingers sticking out of a suitcase, are you going to take a bat to them?
There was some mention about how because she'd done that, she was then afraid of retaliation, but even still, that isn't a self-defense because you initiated the original thing.
I don't know what. I don't know why. Oh no, what just happened? Oh, I thought I lost y'all.
You good? Haha, now I'm taking over the stream. Hello, everybody. So it seems like they're really trying to put out a whole lot of feelers and find some kind of defense that will actually work because they don't seem to know what they're doing. And it just feels like they're trying to stall for as much time as possible.
Draco
You're back.
back. I kept doing this, and when did this happen? When did it do it? When I was doing the.
Jorge died after half an hour. Yeah.
Wibbles. I kept doing this when I was streaming the Gainesville Ripper trial, and Brian Borate was on the stream, and he was like, you need a what kind of cable did he say I needed? I don't even remember what kind of cable he said it was. I'm like, why do I need that? I don't even know what it is. So I went and got an Ethernet cable for this trial, so that kind of stuff wouldn't happen, and it's still happening. And I'm hardwired in now, and it's still happening.
Are you on fiber or what?
I just have an Ethernet cable hooked up from my router, but my internet is it's radio waves. It's hang on, let me go let Bella out.
Yeah, I really wish they'd sort of improve the whole internet thing. We're so reliant on it these days, and it never works properly. Cyberpunk inject directly into your brain. Yeah. The thing that sort of worries me about the whole having a cyber link into your head is they're just going to pump a whole lot of adverts into your head the entire time.
So ours works on a radio tower. It's radio waves, and the tower is literally like the next road over. So we get a really good connection, but sometimes it's just, I guess some days it's slower than other days. Some days it's perfect. And then other
Yeah, it's
days
really funny that.
and our electric company just got like forgot what it's called. Like dang it, what is it called? Like the really, really fast fiber stuff.
Mm-hmm.
I don't know what it's called. Anyway, which I could switch to, but the company I'm with now, they have a waiting list because they because they're good to their customers, they're not gonna put more customers on it than it can handle. So there's a waiting
Yeah,
list.
fair enough.
Yeah, fiber optics, that's it. I couldn't remember what it was called. Um, so if I do switch and then it's not as good, I won't be able to get back on this one. And I can't afford to pay for both at
Hmm.
the same time to try it out, and then so I pay $95 a month, and every time they upgrade to make it faster, they don't up the price. The price stays the same. And they're really, really good. Like I can call them anytime for anything, and they come right out here. So if there's I mean, they can check it from the office if it's like to tell if it's a problem on their end or my end. If they need to come out, they come right out, and they're so nice, and because it's like a little family owned business thing.
Mm-hmm.
So it's not like one of the big companies, nationwide type things. So they're really good.
Yeah, I've been on a wireless internet thing, and I was lucky if I got 2 megabytes a second upload. But I've just
Yay,
switched over to
yours.
the Starlink. You know,
So it's your internet's more stable now? Because I know you were having trouble.
yeah, I'm getting double what I had before, so that's a lot better.
Oh, yeah. I don't need, like, people ask me, what's your speed? I'm like, I have no idea. Like, well, what's your upload speed? I don't know. Well, how fast are you streaming? I don't know. Like, I'm new at this. I know nothing. I just turn it on and do what it tells me to do. Because when I went to buy the Ethernet cable, I was like, "This is what I'm doing," and he's asking me all these questions. I'm like, "I don't know. I don't know. I don't." He goes, "So you're probably just using the default setting?" I said, "Yes. I know the answer to that one. Just using the default setting." Yay, just because it's still here. I accidentally hid you, honey, but I fixed it. Well, yeah, that was dumb, but I think he's done a lot of dumb things so far. Oh, cool. That's good to know.
Hmm. Yeah, you just go to the speed test thing.
And then the guy was, because we went to Best Buy, so then the guy's teasing me. He's like, "Thought you said you were a YouTuber. You don't know what speed?" I'm new. I don't know things yet. Well, I'm not
Yeah.
new. I've been doing this for a couple of years, but not the live streaming part. I started just doing true crime videos. And people were telling me, your channel's not going to go anywhere just doing true crime videos. I'm like, well, how come there's people like Bailey Sarian and people like that that have 1 million subscribers and they do true crime? Oh, okay.
I think it does take time to build up. Yeah,
You
the
got
Starlink
quiet.
thing should be anywhere where you have Sky, it should work. That's what they told me.
You got
And it's better
quiet,
than what I had, so
and I accidentally hid you, and I thought that you went away mad. But then I remembered that you work while you watch me. So then I thought, well, maybe not mad, maybe just working.
your recovery addict
Oh,
set up.
No. Somebody asked him the other day why he had all that stuff. And he said, because I need all that stuff to bring you guys the best quality sound. And I do have to say that he does have good sound because he uses all that hardware because courts have crappy sound. And he uses all that hardware to make all the sound work well. Like any court system that has a crappy sound system, he can tweak it with all of his hardware and make it sound perfect. But I don't want all that mess.
Yeah, he's a tech guy.
Absolutely. Absolutely a tech guy. And he loves it. He's got a new one that he can do like instant rewind and fast forward and freeze frames and all kinds of stuff. And
Wow.
he loves it. We will go back to this, go back to that, and he can just automatically just pop back real quick and then pop right back to the live and it's he did the other day, somebody on the stand pushed their glasses up like that and he did it like a freeze frame, like slow motion and then a freeze frame like this and it looked like he was shooting somebody with a bird.
Oh dear. Yet I'm over here trying to figure out how to get OBS and StreamYard to cooperate.
Yeah, that's why there's a way to are you doing a dual stream or trying to?
I'm just basically recording your stream that we've got on the StreamYard here and broadcasting that at the moment until I can figure it out.
Because I don't know. Yeah, I don't understand all of his equipment like and he even oh, now it's working fast. Cool. Maybe I fixed whatever. I realized I had a bunch of stuff working in like not working, but up in the background.
Mm-hmm.
For some reason, my laptop and my desktop both, when I turn them on, and I know there's a way that you can tell your computer what programs to start up or not start up, but every time I try to find that to tell it what not to start up, I can't find it. I know there's a way to do it though. but it wants to start up like a whole bunch of other programs. So that's what I was doing was I went through and I shut them down, the ones running in the background, and it seemed to have sped up. So I think that was my
Yep.
problem.
Yeah, I always have to close down everything that I'm not using.
Like, you don't like streaming? I like streaming. Streaming's fun when there's people to talk to. Let me go get the dog. I'm coming, darling.
And then you have like free software that you can use, but then you have to pay to actually be able to do anything with it. The original extrovert.
Yeah, you can. Why can't you stream from an iPad? You can stream from your iPhone. You should be able to stream from an iPad. I am an introvert, but I'm also really. Huh. I didn't know that. I'm an introvert, but I'm also a talker. So
Fair enough, yeah.
I'm good at my computer talking to people. I don't want to, like, if I do go out, I'll talk to people, but I don't want to ever go out. It has to be for a darn good reason.
Yeah, I'm sort of the same. Don't
I
go out unless I
do
absolutely have to.
I do theme parks. No, not really. My husband does. He freaks me out because I'll be in the bedroom watching TV and he'll be in the shower and he'll just be talking away. And I'll be like, "Who are you talking to?" Myself. Okay, just making sure you weren't talking to me. He just thinks out loud all the time. I asked his stepmom one time, I was like, why doesn't he have any inner monologue? It's always out loud. He's like, I gotta go do this and then I gotta do that. Darn it, I wish that hadn't have happened or that. It's like everything's out loud. He doesn't think to himself. It's
Yeah,
so
it's
funny.
always funny when people are talking to themselves. You get some interesting insights sometimes. And my little kitties, the white one is Freya, and then the other one is Cleo, as in Cleopatra. And somebody was
Aw,
asking about that
they're,
before.
they're cute. Mine, she's asleep on the couch. She's mean. That's a mean cat. We found her in our shed. You and your fried chicken. I miss fried chicken. But I've lost a lot of weight, so I don't need. Every once in a while I will eat like chicken tenders or maybe like a chicken sandwich, but like the whole like fried chicken, mashed potatoes, coleslaw, biscuit, like the whole spread. I've not had that since I started my diet. Every once in a while, we'll go out and I'll have like a big meal. We went to Sonny's the other night and I had barbecue ribs for the first time since I started losing weight.
Deep fried tarantula. Yeah. No, thank you. I have plenty of spiders in my house, but they're all alive and useful. They can get rid of
Yeah.
mosquitoes and stuff. I'm not interested in eating them.
Yeah, I too have spiders everywhere. Sometimes I catch them and keep them as pets, but the last one I caught him right before the hurricane, so I named him Milton. And he was not eating, so I let him go. He ate one of the worms I gave him. And then the next worm he didn't eat, and he was getting skinnier and skinnier and skinnier. He looked like he was starving, so I let him go back outside.
Fair
So
enough.
this is what I looked like when I started my diet. And this is now, which you probably can't really tell on the camera that much difference. But
Yeah, it's looking a lot better. You're doing really well.
52 pounds.
It's incredible. I bet you feel a lot better too.
I do. But I'm really excited because next time we go, this was actually taken at Universal. You see Scooby Doo behind me. I'll show you the.
It's amazing how many little things change when you lose weight.
Is,
You can suddenly be more flexible and move more and
that is me and my stepdaughters with Shaggy and Scooby Doo at Universal. But I'm so excited because the next time we go, I'll be able to fit in all the rides.
that'll be
And
fun.
yeah, and Travis was like, "How do you know you're going to be able to fit in all the rides?" And I said, "Because I have fit in the rides before when I weighed more than this. Because I kind of like yo-yo back and forth." Thanks, guys. So I know if I fit in them then that I can fit in them now because I'm the lowest I've been. I can't remember when I've been this small. I mean, I'm not small, but since I've been this small. Can we get back to court, please?
You know, one of the things I found interesting was when I lost weight. When I was a bit chubbier, the water, when it would rain, would go around the outside of my face. But then when I lost weight, it goes straight into my eyes, straight into my mouth.
Oh, wow.
It's just my whole face changed shape. It was really weird.
Yeah, my cousin had weight loss surgery and I don't know how much weight she lost. She lost a bunch. I almost don't recognize her like when we FaceTime and stuff, when I first see her, it's weird. Like I almost don't recognize her. Her face looks completely different. It's weird. And my face doesn't look completely different yet, but when I see pictures of then and now, I can see a huge difference in my face. I think I have. Oh, oh, they heard me. All right, come on.
Yeah, that's the thing. Theme parks are supposed to be scary but safe and fun. And then when they fail, it's so bad. We had an incident with Dreamworld, a theme park here, and there was one of those big tube rides where everybody sits in a circle, and it flipped upside down, and the two kids were flung out and actually survived, but none of the adults did. And they've only just started getting to the conclusion of it all. It's so rough. I used to love roller coasters, but I haven't been in ages. I don't know if I could even handle them anymore. I've got old since I've been to the theme parks last.
Yeah, I don't watch those videos.
You're talking, but there's no sound. Is it muted? I'm guessing it's the cord, not you, but
No, there's sound, but I can't
it'd
get
be
my
nice if they
picture.
could.
My picture's not working. I think I'm sharing your screen. I can't
Oh,
get my
okay.
screen to. Well, wait, hang on. Let me try mine again. I don't know why it's not.
That's our reason for the late disclosure on her. And
Okay, I can hear it now.
Michelle
Okay,
Fenner and
now
Okay,
it's
Tori
working.
Shelton.
there we go.
And those are the 911 dispatchers. Having to call them.
Okay, cool.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Statutory does not believe that the lieutenant ever proposed.
Okay. Any other positions, Mr. Owens? Okay, all right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have that thing again, please? If you all still have yesterday's sheets, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
Just excuse them and move on.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the or tennis motion, as to Ms. Boone's request for snacks, the or tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Okay.
All right.
So no snacks.
No snacks.
No snacks. I guess I need to make a new one of this because my face is even. Oh, there's a glare, but my face is smaller now than it was because that's 10 pounds ago.
You've done really well.
I like roller coasters, but I'm kind of picky about them. I'm not crazy about going upside down. If it's just like a quick loop, I'm good. Um, I like them in the dark because I don't like to see where I'm going. My husband's the opposite. He wants to see where he's going. Um, but I think it's because of my back. Because if if I see something coming up that thinks it's going to hurt my back, I kind of like brace for it. So I don't enjoy it as much. I don't know. It just so to keep up her energy. Yeah, but she doesn't eat breakfast. Oh, wait. Yeah, she doesn't eat breakfast. That's the most important meal of the day. I haven't had breakfast yet either. But I have a protein shake every morning usually. Why would you have a nightmare about a roller coaster just out of the blue if you don't ride roller coasters? That is terrifying. I don't watch videos about roller coaster accidents. I watch videos of roller coasters, but I don't watch the ones where there's problems. Me and my stepdaughters, we were at Universal one time and we were in line for a different ride and there was a kid, you know how like the queue lines like they go, like you circle back and you see the same people. So there was a kid in the line ahead of us and we kept, like ended up next to the kid. And he had his phone out and he was watching a live feed of one of the coasters at the park that had gotten stuck. There is a coaster that I will not ride at Universal because I don't like lift hills. I like the ones that shoot you out. I hate like laying back on my back and just that jerky bumpy thing, you go up the lift hill. I hate those. I mean, I know some of them you have no choice. You have to do that to get to the ride part. But this one at Universal, it's straight up. You are flat on your back, going straight up. And this one gets stuck. That's where it gets stuck a lot. I see it stuck there many, many times when I go to the park. And this kid was watching it on his phone while we were in line that day and at another ride. I'm like, I will never ride that one. Never, ever, ever. And I read, I didn't, it's not rumor. I read it like in a magazine or newspaper article or something that one woman wrote it. I think she's either with her nieces or her granddaughters. When she got off of it, she must have got a concussion or something from it because when she got off of it, she didn't recognize her granddaughters. And eventually she did, but like they took her to the first aid station or whatever it is, and it took a while for her to like come back to her senses. So I don't know if
Like
she had
whiplash or something?
yeah. Like I don't know if she had like a pre-existing condition or something that made her susceptible to whiplash or concussion or whatever it was that happened. So I don't know, but I won't ride that. I will not ride that one.
Fair
Oh, I
enough.
always forget to do that. I always forget to turn off after hearings are over. I always forget to turn off the window or click that window shut. So, okay, well, I guess I wonder if we're going to I don't think we're going to have opening statements today. Probably would have if they hadn't had to hash it out over stupid stuff that Owens keeps giving the state. So maybe tomorrow. I'll keep an eye on it though, guys. So
Sounds like they're getting the jury sorted out and they're sort of getting ready to keep moving. Hopefully, we'll get some movement on it.
yeah. So I will let you guys know. But like I said, it's probably not going to be till tomorrow. So, and I guess I'm going to go eat lunch since I didn't eat breakfast. Because
They
I
did say
didn't know.
they'd be
I
back
didn't
at
know
1
there was.
o'clock.
Yeah, but that's for jury selection. If you want to
Okay.
watch, yeah, if you want to watch jury selection, Trial TV Live has it. But I don't want to watch jury selection. I want
Yeah,
to get
fair
ready.
enough.
Yeah, I'm going to go back and watch. I mean, unless you guys want to. Well, no, cuz I don't think I can stream that. Cuz it's not on I started to say Law and Order. It's not on Law and Crime or Court TV. It's on somebody else's channel, so I don't think I can stream that without permission.
Yeah.
So thank you for joining me.
Yeah, thank you for having me on.
This has been fun. So yes, and Christian wants to go back to sleep. So
Yeah. It's 2:30 in the morning. I should probably get some sleep too.
oh yeah, I always forget you're in the future.
Yeah.
Okay, I will see you guys later. Thank
All
you.
right. Bye.
Bye.